Hello and welcome to the Sidebar, presented by True Crime News, taking you inside the courtrooms of high-profile and notorious cases from across the country. I'm your host, Joshua Ritter. I'm a criminal defense lawyer based in Los Angeles and previously an LA County prosecutor for over a decade. You can find me on all social platforms at Joshua Ritter ESQ or at joshuaritter.com. We are recording this on Wednesday, September 10th, 2025. In this week's episode, parole hopes dashed for a mother convicted of murdering her daughter after additional sentencing adds decades to her imprisonment. Plus, a judge's ruling to allow cutting-edge DNA evidence in the trial of alleged Gilgo Beach serial killer Rex Heuermann. But first, the jury foreperson in Donna Adelson's murder trial giving insights into the matriarch's conviction. Our guest this week is Brian Buckmire, a criminal defense lawyer, author, and legal contributor for ABC News. Brian, welcome back, my friend.
Joshua, always a pleasure. Thank you for having me here.
Absolutely. We saw each other at CrimeCon over the weekend. You presented at a panel. I thought you did incredibly well. And I thought, you know what? I haven't bugged this guy to come on our podcast in a while. So here we are.
Yeah, thank you. And you were great as well at CrimeCon. It was great to finally bump into you. There's so many. Oh, God, I want to say how long it's been, but it's always great to see you. And thank you for having me on.
Yeah, finally get to meet a lot of these people in person. We're so used to chatting over computers that it was nice to actually shake your hand. And I'm looking forward to this because I know that you follow a lot of these cases closely, and I always appreciate your insights. So let's jump in. First, out of Tallahassee, Florida, the jury foreperson in Donna Adelson's murder trial is speaking out after the matriarch was convicted of murder, conspiracy, and solicitation in her son-in-law's slaying. The juror told media outlets that she remained neutral throughout the trial, holding the state to their burden, and the jurors went over the charges thoroughly before rendering their verdict. The verdict was ultimately decided in around 90 minutes, making Adelson the fifth conspirator convicted in Dan Markel's murder. The swift decision only fueled speculation about another potential conspirator who could be indicted in the crime. Adelson's daughter, Wendy, the former wife of Markel, featured heavily in the state's case against her brother and mother, but has so far avoided any criminal charges. The foreperson also weighed in on that, saying she expected additional family members to be charged in the conspiracy, noting that she thought Wendy was 100% involved. Adelson wasn't arrested until after the conviction of her son, so Wendy's movements may still be under the scrutiny of law enforcement. First, Brian, this case I felt was probably the greatest test so far for this prosecution team, because you're just one more degree of separation away from the actual triggerman. This is now the let me do the math real quick. 1, 2, 3, 4, fifth person to have been convicted in connection to his murder. Were you surprised that they came back so quickly on this verdict, or was that kind of expected?
No, I was not really surprised at how quickly they came back. 90 minutes is, I would say, quick-ish. Have we seen quicker verdicts? 30 minutes, 60 minutes? Yes. But I think every juror is different. Every group of people is different. And what I could imagine is they got into that deliberation room. They went through all of the different instructions, and maybe they just had a poll. And they just said, hey, what does everyone think? And if they didn't get 11-1 off the bat, they probably got very close to that. And I think it took very little to either get everyone on board, maybe went 11-1 and then 12-0, or maybe it was just 12-0 to begin with. But I think that preliminary kind of raising of the hand was a situation that applied here. And that's probably why it was so quick.
I think you might be right. I mean, we tell jurors, don't make up your mind. Wait till the very end. Don't start to deliberate this until you're with your fellow jurors. But I think it's people's natural inclination that if they're starting to lean a certain way, that's going to become further kind of entrenched in their belief system by the time they get to the deliberation room. And you might be right. They could just be fully cooked by the time they get back there, especially in a case like this with as much evidence as there was. Now we hear from one of the jurors, which is becoming this kind of en vogue trend with juries lately, where the jurors take to social media and just start sharing their feelings on this. One, I want to get into what this foreperson said, but one, I just want to get your thoughts on this new trend of jurors kind of speaking. There's nothing illegal about it, but what do you think about it?
Personally, I love it. As a defense attorney myself and someone who's done trials, I think except for maybe one jury trial where I had to get escorted out of the back after getting an acquittal with my client just because of the fever of the courtroom, I always go and speak to the jurors. And I don't care how many opening statements, cross-examinations, whatever part of the trial that you get, hearing from the jurors is probably the greatest insight as to how the criminal justice system works from a trial standpoint. And I think you are doing a disservice to yourself as an attorney if you're not asking jurors afterwards. And I think it's what a great resource for people who follow trials to get that insight as well, because at some point in time, you may be a juror yourself as well. And understanding it from that point of view, I think is helpful to the system as a whole.
I agree with you. I agree with you, certainly from the perspective of a defense attorney, too. I always want to hear what the jurors say, maybe even on a conviction. You want to hear, is there some little insight, something that might be helpful on appeal? I remember when I was a prosecutor and I would get a conviction, I would hope they'd all take off immediately and just put it in their rearview mirror, and so could I. But whenever they would be outside talking to the defense attorney, I get a little knot in my stomach and make sure I go over there and take some notes so that nothing ridiculous is being said. But this juror in particular weighed in on her thoughts on people who weren't even involved. And she made an interesting point because she feels that even from the small role that Wendy Adelson played in this trial, meaning she wasn't on trial, it was her mother, but she still had some very strong feelings about Wendy Adelson's involvement. So I'm going to put the question to you that's been put to me so many times before. Do you think Wendy Adelson is next? Because everybody else has fallen. She's kind of the last person standing and the person most directly connected to Dan Markel.
So I know, especially my wife included, but people hate when you ask the lawyer a question and they give you like both sides of their mind. It's like, it could be and it couldn't be.
Right.
But unfortunately, I'm in that place. And this is why I say this. I think you kind of talked about at the beginning this web of people that have been convicted so far, 5 people in total. And it's kind of started from the triggerman and the person who was closest to the triggerman, and then kind of moved out from there. And by that logic, we kind of skipped over Wendy, right?
Yeah.
Like Donna is the puppeteer, so to speak, right? But there are some facts that we heard, especially in the closing arguments of this case, of Wendy asking Dan Markel, hey, from July 14th to the 18th, where are you going to be? Hey, you can't go swimming with the children. Driving past the house, even though law enforcement was there, and not really kind of giving a budge. And I think those points lead to the idea of, well, she's next.
Yeah.
But if you had all those facts, logically speaking, she should have maybe come before Wendy. I would have thought, and you're the former prosecutor, I would have thought, go after Wendy, get her a conviction, don't sentence her, and then have her turn on her mother. Because I don't think that Donna's going to turn on the daughter. There's a reason why Donna did this, and it was for her daughter. So I don't think she's going to turn on her daughter to help you with that conviction. You might have gone the other way around. So I kind of go back and forth as to like, is she next?
Yeah, very interesting point. And it is a very nuanced thing that's taking place. I think this prosecution team might be playing 3D chess with this whole thing, because had they indicted Wendy early, they never would have been able to compel her testimony that the way that they have in Charlie's trial and in Donna's trial. So I wonder if, just kind of keeping tabs on her, they granted her use immunity, they force her to testify, but they know that they can't do that if she's also indicted herself. It's an interesting high risk kind of a game that they're playing, because, and I only say high risk because if that is true, well, then you're letting someone that you believe was involved in planning a murder to kind of walk free for the last 10 years or so. So listen, they waited as long and they were as patient with Donna. I think you might be right. I think Wendy could be next. I will tell you this. I don't think she should be buying any one-way tickets to Vietnam anytime soon, if I were her. Yeah. All right. Well, we will keep tabs on that case. It's fascinating. It's remarkable how long it's been. It's been over 10 years. These prosecutors have done nothing else essentially for the last 10 years. Does that kind of blow your mind?
Yeah. I mean, we see it sometimes in federal prosecutions,
right,
especially when you have like these 18 defendant RICO or conspiracy cases where prosecutors will just be married, for lack of a better term, to a case and just all the intricacies of it. But I think before we got on, we were talking about our children. I've got a 3-year-old in the other room taking a nap. I think when this all started, I was still single. Like, by the time it's done, I might be a grandfather. Like, I don't know how long this is going to get drug out.
Whoever Wendy Adelson hires as her attorney may not have even been in law school by the time this whole thing started. Very fascinating.
Yeah.
All right. Well, let's leave it there for now. We'll continue to watch that case closely.
When you think about it, there isn't just one money goal. You know, I've been saving for retirement. Thank goodness my son's already done with college, but there's always something that I'm saving for. Well, today's podcast is sponsored by Acorns. Acorns is the financial wellness app that helps you invest for your future, save for tomorrow, and spend smarter today. It makes it easy to start doing more with your money, even rounding up your spare change to invest automatically. Acorns puts everything into an expert-built portfolio so you're investing wisely, not wildly. I know investing can be confusing at times. There's no one way to do it, and there's no rule book that you must follow. That's one of the reasons I like Acorns. It makes investing simple. Sign up now and Acorns will boost your new account with a $5 bonus investment. Join the over 14 million all-time customers who have already saved and invested over $25 billion with Acorns. Head to acorns.com/TCN or download the Acorns app to get started. Paid non-client endorsement. Compensation provides incentive to positively promote Acorns. Tier 2 compensation provided. Investing involves risk. Acorns Advisors, LLC is an SEC registered investment advisor. View important disclosures at acorns.com/TCN.
Let's move to Sullivan County, Tennessee, where a mother convicted of murdering her baby daughter received additional decades in prison for charges related to the killing, ensuring she will never see the outside of a cell. Jurors found Megan Boswell guilty on a staggering 19 charges in the death of her daughter, Evelyn, who was reported missing in 2020 and later found in a trash can on the Boswell's family property. Boswell received a life sentence for the murder charge with parole eligibility after 51 years. However, the judge sentenced Boswell to an additional 33 years for the remaining charges, tearing into the woman for her behavior and callousness throughout the trial. The convicted killer continues to maintain her innocence, using her sentencing appearance to proclaim that she was treated unfairly throughout the investigation and subsequent trial. The judge disagreed, reasoning that society needs to be protected from the evil that lurks in her, closing the door on any chance of parole. I get this question a lot, how much of a sentencing hearing, an actual hearing, and how much of it is just kind of a drama playing out when the judge already knows what the judge is going to do. We see this in cases even where it's kind of the judge's hands are tied as far as sentencing, but we'll have these kind of extended sentencing hearings where victims will speak, the defendant will speak. Have you ever experienced a situation where it actually does matter what's taking place during a sentencing hearing?
So, Josh, I get this question as well. And what I usually tell people is, don't forget, when you watch a lot of these true crime series, shows, cases, you're looking at sometimes the worst of the worst. And when you're getting into those types of cases, when it comes to sentencing and the general sentiment of both judges and society in terms of how much jail time or prison time that person should face, we're all pretty much in agreement. You're not going to get a lot of arguments. But that's like, what, 1%, 0.5% of cases? A lot of times we're having cases where, the victim impact statements, yes, the mental health or how the person grew up or their circumstances can change a sentence from 20 years to 15 to 10. I've had cases in court where the judge is like, you know what, Mr. Buckmire, I was going to give your guy 20, but now that I hear this, I'm going to give him 10. He's already served 5. He's out in 5. And I think that's the more common case when you practice in this area. But when you only watch these true crime cases, I can understand why you're like, why does it matter what anyone says?
Right. Right. What are we doing here? They're getting life anyways. What do we care what anybody has to say about this? You're right. You're absolutely right. It is an important hearing in the vast majority of cases, just not many of the ones that have media attention. Something else happened in this case, and I'm asking this question not so specific to this case, but you have so much experience with this, where we see prosecutors add multiple charges to a case. This is a murder case. End of the day, that's what this was all about, whether or not this poor baby 2-year-old was killed by her own mother. But then we've got the child abuse and the endangerment and all of these other dozens and dozens of other charges attached. Walk us through that. Why might they do that? Is that a good or bad thing? What are your thoughts?
So I look at this in two different ways, right? In terms of just piling on charges against someone. And one I think is far worse than the other. And I think this is the lesser of the two situation. And this is what I mean by that. If you're talking about a person committing one act, right? And the example I always give that's very easy is, when you use it as an example, Josh, I punch you in the arm, right? In the state of New York, that's assault because I assaulted you, I hit you and caused physical harm. That is menacing because you might be fearful of the second hit as well. And it's harassment because I alarmed and annoyed you. And that one action, you can get 3 different charges. Now, we all know that I punched you. If I say, Josh, I'm going to punch you in your arm, and you know I'm only going to punch you once, it's garbage to say there's menacing. It's garbage to say harassment. And in that situation where you get a top charge, you knew what I was going to do, and you just throw in the other ones that are lesser because you're like, you know what, we're going to get him on something. I'm not a fan of that. And you see that when it comes to murder charges. You say, I'm going to charge him with murder 1, 2, 3, manslaughter, this. It's like, guys, you have all the evidence to know this is murder 1. You're just trying to catch him on anything by doing all of this. That I think is very bad. Here, when I look at all the individual charges of the child abuse, the child neglect, the false reporting, the murder, yes, it's a murder case, but she did in fact do all of those separate acts in what she did after the fact of this child being missing for 3 months. And so for that, I don't like it, but I understand it a little bit more than the first example I'm giving you.
Yeah. No, I completely agree. I think it can be, like anything, abused. In some circumstances, I think it's absolutely appropriate. And in fact, in other circumstances, I think it actually hurts the prosecution in that it distracts from their main charge. And it sometimes can confuse a jury. I mean, you charge 19 different types of crimes, you're going to have to prove 19 different crimes, and you have to show people the elements of all those and how they apply. And maybe your main crime might get lost in the noise, but certainly not the case here. And I appreciate you walking us through that. One more point on this case is that a large part of this trial was about whether or not, and I hate to talk about this stuff because when we're talking about the murders of children, it just kills me, but whether or not this poor baby was actually dead before she was wrapped up and placed inside of the garbage, or if she died because of that. In other words, if it was some sort of positional asphyxiation, which is a big thing. We're talking about now perhaps the difference between murder or some other type of crime, right? On appeal, though, is that something that can be re-litigated? In other words, is appeal about questions of fact or questions of law generally?
So you, depending on your arguments and what you have as a defense attorney, you try to muddle the line and you make it both or whatever's advantageous to you, right? In terms of appeals, the most popular ones are mistake of law and ineffective assistance of counsel. And mistake of law kind of branches out in many different ways. As a defendant, you would either say, hey, Your Honor, you made a mistake of allowing this information to come in, or you made a mistake of not allowing this information to come in. The prosecutor made an error in this determination, or even for ineffective assistance of counsel, my own attorney made this mistake. And because of the mistakes of law that are affected by the facts that then follow, that's why I should have an appeal. That's why I should have these charges dismissed, have a new trial, whatever the relief you're seeking there. And so I think mistakes of law and fact are often wedded together to try to make the best argument possible.
I think you're right. And I think that's something that's hard for people to understand sometimes, that an appeal is not just another trial, another bite at the apple, that you have to present some specific question to the Court of Appeal of why some mistake was made during your trial that gives you the opportunity to take a second look at it. Thank you so much for explaining that as well as you did. Let's move to our final case here out of Suffolk County, New York. Rex Heuermann's defense took a major loss in a pretrial hearing after a judge's ruling to allow DNA evidence implicating Heuermann in the murder of several women. Both sides have been sparring over the evidence for months, which utilizes breakthrough technology to build genome sequences from damaged or hard-to-test samples. While Heuermann's defense claimed the technology was unproven and not widely accepted, the ruling went in prosecutors' favor, and they claim the scientific breakthrough links Heuermann to 6 of his 7 alleged victims discovered in Gilgo Beach. All right, let's first get into this ruling made by the judge here. This was part of a Fry hearing. It took place over several different weeks. They were having it on specific days, but they kept on coming back over the course of several different weeks. Finally, the judge rules in favor of the prosecution. But really what it came down to was something, correct me if you feel differently, but something that was kind of particular to New York, in that this type of science had not been used in New York before. Therefore, the defense is challenging it, saying, hey, can't use it here. It's not accepted here. And what we're dealing with is what's called whole genome sequencing. With this judge's ruling, do you think that will change things in the practice of law in New York?
Oh, New York has changed. And as someone who practices in New York, we were keeping our eye on this because we wanted to see how DNA is going to be used in this state. And this opens literally the floodgate for this technology to be used. Just kind of like a backtrack just in case people aren't following us, because I know sometimes I speak to illegalese. Fry hearing comes from a Supreme Court case, but basically just says, hey, you've got the scientific method. Do other people agree with it? Is it this widely used? Or is this some kind of junk science that you're throwing at us for the first time? New York still used the Fry standard. The feds and other states use the Daubert standard, another Supreme Court case, which kind of does the same thing but has different elements and whatnot. For the most part, when we look at DNA for most of the country, not using this new full genome sequencing, this is a very layman's dumbed down version of it. But think of it like my fingers, right? My fingers have different heights to them. And oftentimes when we're reading DNA, we say, okay, this is Brian's DNA. This one's small, this one's kind of tall, this is this. And if it matches, then you're like, okay, that's Brian's DNA. That's his hair sample. That's how we know he was there. It's his skin sample, saliva, whatever it is, right? With the genome sequencing, it's a far more exact type of science and interpretation, but it's almost light years ahead of what we've done in New York before, that there's this question of, is this scientifically accurate? Is it okay to take degraded or very small amounts of DNA? Because we're talking about the skin cells that are attached to the hair. You don't actually test the hair when you test the DNA. You actually test the skin follicle on the hair to try to see if that person is there. We know that multiple hairs were on a lot of these victims, and that's how they're connecting Rex Heuermann to them. But those skin cells were degraded. They were too small for the typical science that we use in New York and for a lot of the country. So instead of doing that finger thing, they're saying, I'm not going to take you too far back to science class, they're saying there are 4 building blocks of DNA. If you remember elementary school or high school, wherever you learned it, that A, T, C, G. And instead of doing this, you're like, okay, does the A, T, C, G, C, G, A, T, does that match up? And you could do that for much smaller parts of DNA, but that's a long way away from what we've done in New York so far. And the argument was, we get the science is new, but we don't think it's been tested enough and widely accepted enough to use it here. Now New York says yes. And so we've got a whole new ball game here in New York when it comes to DNA.
I thought you explained that extremely well, because it is a very complicated concept to understand. But basically what you're saying is that if were it not for this kind of technology, and we call it breakthrough and cutting edge, it's been around for a while. They have been using it, but to use it in a criminal context in the state of New York, this will be the first case to ever do it. And it is a type of science that was not available years ago. And had it not been available, they would not have a match in this case. That's the point I'm trying to drive home, is that it was so central and important to this case that there's a very good argument that had the judge made a different ruling, or had that science not existed, 6 of those 7 victims would not be charged against Rex Heuermann. So this was not just about kind of the details and intricacies of breaking through science, but whether or not they could even hold up a case against him. True?
Yes, I would still say there was other circumstantial evidence that they could have connected, but as you and your viewers know, people love DNA. Yeah. If you can say that your DNA is on the tape or the body or the burlap of a victim, you're 9/10 of the way there for a conviction. If it's not there, you still got some evidence and you still got some arguments, but people love DNA. It's a very convincing argument.
Yeah. Yeah. Speaking of, Now that the DNA is coming in, and now that that will, like you said, put the prosecution probably 9/10 of the way there to convincing a jury, what does the defense do at this point? I mean, they challenged this as legally as they could. It's coming in. I would usually say, well, now you need to find an innocent explanation for why your client's DNA ended up there. But now they've got 6 different people whose DNA happened to end up on 6 different victims. Is there an argument to be made at this point?
Oh, Joshua, don't challenge me with a good time. Come on. I love playing arguments. So what I often tell clients, what we do is, hey, there's DNA here. The first thing we want to do is we want no one to hear about the DNA. And so we fight admissibility. If we lose that battle, then I often tell my clients, hey, there's a difference between admissibility and believability. Right now, we lost the admissibility argument. Now it's a matter of arguing to a jury believability. Now, can I argue with a straight face that Rex Heuermann is a purveyor of women of the night, that he sends his wife and child away on vacation so he can have his own personal time with these women, and he just so happens to have had relationships in close in time with someone who is stalking the same prey? I don't know, but that might need to be the argument. I think the only argument here that you have for them is, I bet you that there are 7 different hairs on that woman, because she probably had 7 different clients at that time. And you could probably connect one person with 3 of them, and one person with 2 of them, and one person. You just so happen to be able to connect my client with 6 of them or 7 of them, or more, because they're trying to add more. I would also make the argument for him is that there are more Gilgo Beach murder suspects than there are that he's being accused of. And so the argument there would be, I bet you can find another man who had a similar relationship with these women on the ones that he's not being charged with. So what about the person who's been on 5 of the 12 and my guy's only on 7 of the 12? Like, I think that's the kind of argument that you've got to work with once you know the DNA is coming in. You've got to give it an innocent, or paying for women for this is not necessarily innocent, but non-murder explanation is what I would say.
Right. No, you're absolutely right. And I think that probably will be the argument. Again, I think both you and I agree that it's probably not an argument that will carry the day, but it is probably the only logical argument that they have left. And that's kind of ignoring all the other circumstantial evidence, including the blueprint that was found on his hard drive and a lot of other kind of really awful, horrific stuff that we don't need to get into right now.
Yeah, this is the argument that I make when it comes to DNA and hair. I say DNA does not prove that someone committed a crime.
Right.
We started off by talking about how you and I saw in CrimeCon. I think I'm pretty sure I was wearing my suit when I saw you and I gave you a big bear hug. I'm going to bet that my wife's DNA was on your jacket. I'm going to bet that my son's DNA is on your jacket, because every time they leave, my son's sneezing on the side of my jacket. My wife's giving me a kiss goodbye. Probably my Doberman's hair is on you as well. You didn't meet my wife.
I'm just covered in your DNA.
You're covered in my whole family's DNA. But you didn't meet my wife. You didn't meet my child. You didn't meet my dog. So the presence of their hair or their DNA on you does not mean they were with you. It just means it was transferred. And if you can give an explanation for that, that's a long way to help in your case.
Yeah. It's circumstantial evidence, and we forget that sometimes, that all it says is that we believe this is evidence that someone may have been at this location at this time, or not even at this time, at this location at some point in time. But with DNA, it's even not as, what's the word I'm looking for? It's not as convincing, but sometimes even more problematic than, say, a fingerprint, because a fingerprint can't be transferred, whereas as what you just explained to us, DNA can be transferred. You can have, initial transfer from a person to an object, and then that object is moved. But you can even have from a person to an object, and from that object to a third object. So you're talking about secondary transfer. So yes, incredibly convincing stuff, incredibly powerful because of how little we need to make a match, but also it all depends on the arguments that can be made as to how it ended up there. So thank you for enlightening on all of that. That is a case, obviously, we will continue to be watching, even though a trial has not been set, but it's a fascinating case of great importance in New York and throughout the country. But that's where we're going to have to leave it this week. As always, thank you so much to our listeners for tuning in. Brian, where can people find out more about you?
Yeah, so you can check me out on Twitter or X, Instagram, the Buck ESQ or Brian G. Buckmire. I still have my podcast, Bad Rap, the case against Diddy, where we follow the entire trial of Sean Combs. We're going to have our final episode on October 3rd when he is sentenced. Make sure to check that out wherever you get podcasts on Spotify or Apple Podcasts. And we were actually, I think, voted best of 2025 so far. So some people like it. And then if you haven't checked it out, go check it out.
Definitely check it out. Encourage everybody listening to check it out because you did some real fantastic coverage of that case. I remember watching a lot of the stuff you were doing for ABC, and the podcast is amazing. I'm your host, Josh Ritter. You can find me on Instagram and Twitter at Joshua Ritter ESQ. And if you want to hear my thoughts and coverage on even more true crime cases, please check out my YouTube channel, Courtroom Confidential. And of course, you can find all of our Sidebar episodes wherever you get your podcasts, and we would love to hear from you. If you've got questions or comments you'd like us to address, please tweet us your questions with the hashtag TCN Sidebar. And thank you for joining us at the True Crime News Sidebar.